Hi, I'm attorney John Mangan, a board-certified lawyer in the area of wills, trusts, and estates here in Florida. Occasionally, we will receive questions from clients or prospective clients about, can a husband and wife have a joint will? So that's the topic for our conversation today. The first thing to be aware of is that the state of Florida does not recognize joint wills. So perhaps it's possible in other states, but here in Florida, husband and wife each need to have their own wills. I can understand where the question comes from. A lot of times, husband and wife will have assets owned jointly. They do a lot of things together from a legal perspective, but wills are not something that we can combine. Let me give you some reasons why, even if it was possible, a joint will is not a great idea. First of all, think about the fact that when you create a will, you can amend it at any time. Well, if you create a joint will, then that would require both spouses to amend the will at the same time. And what if they have a difference of opinion? Or what if one of them has been incapacitated or has passed away? Here are some other considerations. New marriages. Oftentimes, spouses have different ideas of what they want to do. Perhaps they have no children together, at least not yet at this point. And while they might want to leave things to each other upon the first death, upon the second death, they each may have very different ideas. The same concept applies in a second marriage. Oftentimes, each spouse may bring children from prior relationships. And so while they may want to benefit each other to some extent upon the first death, at the second death, they could have very different ideas about where they want things to go. Also, what if there is a pre or a postnuptial agreement? Each spouse may wish to have separate lawyers drafting their own plans, which if there was a joint will, that makes it pretty difficult to do. Some other situations that might make it very difficult to implement a joint will. What if we have a large disparity in age between the spouses? They may be at very different points in their life, where one of them perhaps is thinking about retirement or is retired already, and eventually the cost of long-term care. And the other may just be getting started in their life, in their professional career, and so forth. Also, sometimes we have great disparity between the wealth of one spouse to the other, and therefore they have very different considerations to think through in their planning. One might be concerned about estate tax, whereas for the other, it's not a concern at all. So as you can see, there are a lot of situations where it's simply easier to have separate documents between spouses. That way, each spouse can make their own decisions about not only who they wish to benefit upon their death, but also who they wish to name as their fiduciaries in the event of their incapacity or their death, who can make financial decisions or healthcare decisions for them, and ultimately who's going to be responsible for administering their estate, or if they have a trust, who's going to be their trustee when they pass on someday. So hopefully you found that helpful. If you have any questions, please feel free to reach out to us. We look forward to hearing from you.